Welcome to the debate. How do you legally dismantle a massive political opposition coalition without, ever casting a single ballot? Well, you use the electoral calendar.
Right. Or, to look at it from the other side, how do you prevent a national election from collapsing under the weight of dozens of empty, non-functioning political parties? You enforce the Constitution.
Today, we are looking at a masterclass in constitutional mechanics unfolding right now in Nigeria. It centers on a specific legal battle in Abuja, that suit FHCH BJCS 2637-2026 at the Federal High Court.
Yeah, it's a massive case.
It is. The suit is basically seeking a sweeping mandate to force the Independent National Electoral Commission, INEC, to deregister the African Democratic Congress, or the ADC.
Right, and it's not just the ADC. It's 4 other parties, too. The Action Alliance, Action People's Party, Accord, and the Zenith Labor Party.
Exactly. And all of this is happening right ahead of the critical 2027 elections. So to frame our disagreement today, the core question we're pulling apart is whether this deregistration suit is a necessary, strictly constitutional enforcement of electoral performance thresholds.
Which I believe it is.
Right. Or, as I will argue, it's a highly calculated, politically timed weapon designed by the executive to neutralize the primary opposition coalition platform before the 2027 elections.
And I'll argue that this suit represents a legitimate, necessary enforcement of the mandatory deregistration provisions under Section 225A of the Constitution, strictly to solve the genuine systemic problem of ballot congestion.
Well, let's test that theory. The idea that this is just regulatory compliance. Because frankly, the timing is highly suspicious. If you want to understand the mechanics of political suppression, you have to look at the timeline.
Okay, lay out the timeline then.
So this suit was filed on April 23, 2026, precisely one day after the Supreme Court heard the ADC leadership appeal.
Right, a Tuesday.
Yeah, and on that exact same day, the Attorney General of the Federation, Prince Leet Fagbemi, formally intervened in support of this deregistration. He threw the weight of the government behind shutting the party down on the exact day the Supreme Court vacated the status quo order that had been, strangling the ADC.
To translate that from legalese for a second, just so we're all clear, the Supreme Court basically removed the temporary legal shield protecting the ADC, right? It left them exposed.
Exactly. The shield drops and instantly the Attorney General strikes. But beyond the suspicious timing, there is a glaring factual contradiction at the absolute core of this suit. We have to talk about Section 225A of the 1999 Constitution as amended.
The law that empowers INEC to deregister a party?
Yes, and it lays out very specific performance thresholds. It says a party can be deregistered if it fails to win 25% of votes in one state in a presidential election, or, and this is the crucial part, if it fails to secure at least one elective seat at the national, state, or local government level. Just one.
Right, at least one.
Well, the ADC objectively meets this threshold. They successfully elected Lake Abajade to represent the Yagba federal constituency in Kogi State in the House of Representatives. You cannot deregister a party for having 0 seats when they clearly occupy a seat in the National Assembly. It's an objective fact, and I think it exposes the Attorney General's intervention for what it really is. An attempt to weaponize the courts to bar the mega coalition of Atiku, Obi Kwankwaso, and Amechi from using the ADC platform during the upcoming May primary windows.
Wait, hold on. 1 seat? You're talking about 1 single seat out of hundreds of national and state legislative positions? Your perspective requires us to view a strict reading of constitutional law as, like, an executive conspiracy, simply because the ADC managed a single localized victory.
But the Constitution doesn't say a party needs a respectable number of seats, right? It specifically says at least 1. They have 1. If a rule says you need $1 to enter, and I hand you $1, you can't turn me away because you suddenly decided I should have brought 50.
But you're looking at this like a one-time cover charge. The law is actually designed to measure long-term systemic viability. We really need to examine the precise legal language of Section 225A of the Constitution alongside Section 75, subsection 4 of the Electoral Act 2022.
Okay, what's the operative word there?
The most critical word in those texts is shall. The law states INEC shall deregister parties that fail to meet these performance thresholds. It's mandatory language. It strips away administrative discretion.
But they didn't fail. They have the seat in Kogi.
They have persistently failed everywhere else. Let's think about this conceptually. It's like a massive corporate conglomerate that is bankrupt in 35 states, utterly failing to provide goods or services to millions of people, but
They have one profitable storefront.
They keep one single profitable storefront open in Kogi State. You're looking at that one storefront and saying, look, they made a profit. The business is thriving. But the law requires regulators to look at the massive overall deficit.
I don't buy the corporate conglomerate metaphor, to be honest. A political party isn't a business maximizing profit. It's a vehicle for democratic representation.
But it still has to be viable.
Sure, but if the people of Yagba federal constituency chose Leke Abejide, then the ADC is successfully representing them. How can the AGF, represented in court by a formidable legal mind like Professor J.O. Olatoke, logically tell a judge that the ADC fails the threshold? The assignment is complete. It's on the teacher's desk.
Because the statute does not just look at a single isolated anomaly. We are talking about the concept of persistent failure. And, it is crucial to remember who actually brought this suit in the first place.
The incorporated trustees of the National Forum of Former Legislators.
Exactly. Led by Honorable Igwe Raphael Nana. This is an independent body of former lawmakers. It is not the ruling party. It's not the APC. And furthermore, while the suit may have originally targeted the ADC, it was explicitly amended to include 4 other parties.
Right, Action Alliance, Accord, and the others.
Right, so if this were merely a surgical strike engineered by the executive to take out an opposition coalition's specific platform, why broaden the scope to these other entities?
Oh, because broadening the scope is the perfect camouflage. I mean, if you want to take out the one party that actually threatens you, the ADC, you bundle it with 4 other non-threatening parties so it looks like routine administrative housekeeping. It gives the exact illusion of neutrality you're arguing for right now.
That is quite the leap. Honestly, the courts are simply being asked to examine whether an isolated electoral success in Kogi State overrides a broader, persistent pattern of underperformance across national, state, and local elections. The strict statutory text exists to ensure that parties demonstrate broad, sustainable viability, not just a blip on the radar.
But that strict legal reading ignores the pressing reality of how legal maneuvers are actually utilized in real-world political timelines. If anyone is wondering why an argument about one seat in Kogi State matters so much on a national level, it comes down to the calendar.
Well, the deadlines are definitely tight this cycle.
They are practically suffocating. The INEC membership register deadline is May 10. That is merely days away. That's the deadline for a party to submit its official list of members to the Electoral Commission.
Right. And if you aren't on that register, you don't exist for the primaries.
Exactly. And the primary window entirely closes on May 30. So let's look at the mechanics of what happens next. Justice Peter Laifu has adjourned the hearing at the Federal High Court to early May. If the court grants the plaintiffs an interim order, do you know what that actually does mechanically?
An injunction restraining the ADC from conducting political activities pending the determination of the main suit. It pauses their operations.
It acts as a timed judicial detonation. It freezes the party immediately. It legally blocks INEC from accepting the ADC's membership register on May 10, and it blocks them from holding primaries by May 30. That interim order instantly neutralizes the relief the Supreme Court just gave them without requiring further Supreme Court action.
I hear you, but an interim injunction is a standard legal tool. It's just meant to maintain the status quo.
But in an election cycle, maintaining the status quo is the penalty. If they are frozen in early May, they miss the primary window entirely. Even if the ADC wins the actual court case in July, it's too late. The INEC server is closed. The 2027 train will have left the station without them.
It's unfortunate timing, I'll grant you that.
Unfortunate? You cannot look at the Attorney General, a member of the Federal Executive Council, who serves at the pleasure of the president, aligning himself with this specific suit at this exact moment and call it a coincidence. The timing is the mechanism of the suppression.
Look, I understand why the timing looks incredibly suspicious to opposition analysts. It makes for a great political thriller, but we need to remember how the law mechanically operates here. The Attorney General didn't file this suit.
He didn't have to.
He is the second defendant. He was dragged into this matter by the plaintiffs. When a plaintiff sues INEC and names the chief law officer of the Federation as a co-defendant regarding a constitutional interpretation, the AGF cannot just sit back and shrug.
But he didn't have to formally support the deregistration. He chose to align with it.
He must respond to the constitutional question presented to him. That is his job. If his legal interpretation of Section 225A is that INEC has been derelict in its mandatory duty by allowing persistently underperforming parties to clutter the ballot, he is legally obligated to say so to the court.
Even if it conveniently destroys the primary vehicle of his boss's political rivals?
We must be very careful not to conflate the political ambitions of an opposition coalition with the basic structural legal imperative of maintaining a functional electoral system. Just because the enforcement of a law inconveniences a political alliance does not render the law invalid, nor does it make its enforcement malicious. If we suspend the application of Section 225A every time an election approaches because someone claims it's, bad timing, we will never actually solve the problem of ballot congestion.
Okay, let's talk about that problem then. Systemic health versus democratic pluralism. I acknowledge that ballot congestion is a real issue. A ballot paper the size of a tablecloth serves no one.
It doesn't just serve no one, it actively harms the voter. We really need to look at what ballot congestion physically looks like at a polling unit in Nigeria.
I've seen them.
Right? When you have a ballot with 70 or 90 political parties, the logos are shrunk down to the size of a postage stamp. Illiterate and elderly voters literally cannot find their preferred party. The ink bleeds across tiny lines, leading to massive spikes in canceled, invalid votes.
It is a logistical issue, yes.
It's a logistical nightmare for INEC to print, transport, and count. It dilutes voter attention and strains administrative resources to the breaking point.
I am not denying the logistics, but we have to balance Section 225A against Section 40 of our Constitution, which guarantees the fundamental right of association. When you use mandatory deregistration mechanisms against what is emerging as the principal opposition platform, you cross a very dangerous line from systemic management into democratic suppression.
But Section 40 does not give you an unconditional right to indefinitely maintain a registered political party on the public ballot if you cannot demonstrate systemic political viability.
But look at the broader context that civil society is pointing out. There is a documented worrisome trend where the ruling APC is perceived to be sponsoring internal crises within minority factions of parties to weaken dissent.
That's a strong accusation.
But the ADC explicitly described INEC's previous derecognition of its Mark-led faction back in March as the work of ruling party agents. When the state's legal machinery is perfectly aligned with efforts to dissolve the exact vessel the opposition intends to use, it threatens the very concept of a multi-party democracy. I mean, isn't democracy supposed to be a little messy?
Messy is one thing, broken is another. And we cannot ignore precedent here. In February 2020, INEC successfully deregistered 74 political parties under this exact same legal framework. 74 parties wiped off the register in one stroke.
Right, the 2020 purge.
Why did they do it? To save the electoral process from collapse, and the courts at multiple levels, the Court of Appeal and the Supreme Court, they consistently upheld that mass deregistration. They prioritized the framework of Section 225A to prevent endless party proliferation.
Yeah, but those 74 parties in 2020 didn't have a sitting member in the House of Representatives. They actually failed the threshold. The ADC did not.
Which brings us back to the purpose of a political party. A functioning democracy requires political parties to be broad-based, widely supported institutions that consistently engage the electorate across the country. What we frequently see instead in Nigeria are political parties being utilized as special purpose vehicles, SPVs.
Explain what you mean by that in this context.
An SPV in politics is essentially a temporary shell company.
It's a hollowed-out party structure used as a last-minute shelter for elite political coalitions who need a platform because they had internal squabbles in the major parties.
So you're saying the ADC is just a shell?
They don't build grassroots support, they just rent the party's logo for the election cycle. The legal framework of Section 225A exists precisely to enforce a standard of viability, so our ballot isn't just a parking lot for elite SPVs.
But if a coalition of heavyweights, like Atiku, Obi, Kwankwaso, and Amachi, decides to use the ADC, that instantly makes it viable. It brings millions of voters to that platform overnight.
Democratic theory suggests they should build or maintain a party that organically meets all constitutional thresholds over time, rather than relying on a historically underperforming party and crying foul when routine constitutional maintenance is applied by the Attorney General.
Calling the ADC historically underperforming in a way that justifies its immediate elimination completely ignores the real electoral footprint it established in 2023. Beyond just Representative Abajide and Kogi, they fielded candidates who performed credibly across various levels.
But not enough to pass the systemic threshold.
Because the criteria for deregistration isn't failing to be a massive, dominant national institution. The criteria is explicitly, mathematically defined in the Constitution. One elective seat. You are arguing that the court should view this holistically, but the Constitution does not say a holistic impression of viability.
Section 75, subsection 4 of the Electoral Act 2022 makes it abundantly clear that INEC has a duty to maintain a register of viable parties.
But by moving the goalposts to persistent failure despite the party meeting the explicit constitutional benchmark, the Attorney General is effectively rewriting the Constitution via court filings to suit a political end. And doing it mere days before the INEC membership register deadline is a deployment of the law as an electoral weapon, plain and simple.
Well, if we accept your premise that one seat and one constituency forever immunizes a party from deregistration, we essentially render Section 225A toothless.
It wouldn't be forever, just for this cycle.
We would be telling INEC that as long as a party can scrape together a single local victory every few years, they are entitled to perpetually clutter the national ballot. The National Forum of Former Legislators brings a valid public interest argument here. The Nigerian voter is poorly served by a chaotic, overloaded ballot.
Yet the courtroom itself is part of the battlefield. When the judicial process, specifically the mechanism of the interim injunction, is used to freeze a party right at the moment of peak electoral relevance, the damage is done before the substantive suit is even decided. We are watching the law being used to preemptively decide an election before a single Nigerian voter even gets to see a ballot paper.
I understand the gravity of that, but we cannot suspend the administration of justice simply because the electoral clock is ticking. If a party is operating in breach of constitutional requirements, the proximity to an election does not grant them amnesty. In fact, the integrity of the 2027 elections depends on a ballot that is legally sound and free of parties that shouldn't constitutionally be there in the first place. If the ADC truly meets the threshold in a way that satisfies the legal definition of systemic viability, they will have the opportunity to prove that before Justice Peter Leifu. The courtroom is exactly where this should be resolved, not in the court of public opinion through allegations of executive conspiracy.
Well, what we definitely converge on is the profound gravity of the stakes involved here. We are essentially watching a high-stakes race to the starting gate.
Absolutely.
On one hand, you have the Supreme Court's restoration of the ADC's legal recognition. On the other hand, you have the Federal High Court's potential interim order in this deregistration suit. Whichever judicial event asserts itself first will fundamentally alter the landscape of the 2027 elections.
It is a delicate, almost razor-wire balance between preventing unsustainable party proliferation and protecting the democratic pluralism that our system requires. The courts are being asked to solve a problem that is simultaneously deeply legal and inherently political.
It's a situation that requires everyone listening to look closely at the mechanics of our electoral laws, to read the nuances of Section 225A, and to ask themselves what kind of democracy they want to see. Because when the timeline of a court docket has the power to dismantle a presidential coalition before the primary window even opens, We are no longer just debating the law. We are debating who gets the right to be on the ballot at all.
Welcome to the debate. I mean, imagine a political party throwing a massive champagne-popping celebration for a Supreme Court victory.
Right.
But while they're doing that, in a courtroom literally right next door, the government's chief law officer is quietly filing the paperwork to wipe their entire political party off the map.
It really is a stunning juxtaposition. You have this absolute public jubilation masking an incredibly severe existential threat.
Exactly. And, that tension between the public spectacle and the actual structural reality is our focus today. Because on April 30, 2026, the African Democratic Congress, the ADC, dropped two massive political bombshells.
Yeah, and the timing there, landing on the exact same day, is certainly not a coincidence.
Not at all. It is a deliberate signal. First, we had a unanimous 5-member Supreme Court judgment regarding the party's leadership.
Right, the leadership crisis.
And second, an exclusive report from legit.ng detailing these very discreet 2027 presidential talks with former President Goodluck Jonathan.
Which is just a massive development.
It is. So the core question we have to answer today is this. Do these dual developments represent the consolidation of a formidable, unified opposition force genuinely capable of reclaiming power in 2027?
Or, on the flip side, do they serve as a smokescreen, like masking deep structural vulnerabilities, unresolved legal perils, and the imminent fragmentation of an already dangerously overcrowded coalition?
Right. And just to lay our cards on the table, from my vantage point, the ADC's current trajectory is a masterclass in political consolidation and strategic coalition building.
And I view the party's position as fundamentally precarious. I mean, they are relying on procedural illusions and a highly risky aspirant calculus that could very easily tear their coalition apart.
Well, let's unpack those starting positions. Because I look at the ADC right now and I see an undeniable momentum shift.
Okay.
The Supreme Court's decision to vacate that status quo antebellum order is a decisive victory. It officially legitimizes National Chairman Senator David Mark and National Secretary Ugbeni Ralph Arabissola.
But just temporarily, right?
Well, they now have the keys to the vehicle, and you can see this institutional strength in how they're behaving. Specifically, their highly confident demands for INEC Chairman Professor Joash Amubatan's resignation, dating back to the April 25 Ibadan Declaration.
Right.
And topping that off with the prospect of adding a 58-year-old former president like Goodluck Jonathan, the man who holds the ultimate democratic legacy of the 2015 peaceful power transfer. That provides this coalition with a unifying, heavyweight candidate from the South-South.
I come at it from a totally different way. What you're describing as momentum, I see as the projection of a completely false sense of finality.
A false sense of finality? How?
Because if you look at the actual mechanics of that Supreme Court victory, it's strictly procedural. They simply remanded the substantive Nafu-Bala Gombe case back to the federal high court.
Sure, but it still cleared the immediate hurdle.
But more alarmingly, the party is completely ignoring an existential threat. On that exact same day, the Attorney General of the Federation formally joined suit no FHC ABJ CS 26372-026.
Right, the deregistration suit.
Exactly. Seeking to deregister the ADC entirely for failing the Section 225A electoral performance threshold. Furthermore, injecting Jonathan into a field that already contains Adiku, Peter Obi, Rabiu Kwankwaso, Rotimi Amachi, and Mohammed Hayatuddin that inherently fractures rather than unites the coalition.
Okay, before we get to the presidential ticket and the internal dynamics, we absolutely have to examine the legal ground this political vehicle is parked on.
Let's do it.
Because former Governor and Senator Aminu Tambol called this ruling a landmark affirmation of the rule of law that puts all questions around party leadership to rest.
Yeah, I saw that.
And national spokesman Malam Balaji Abdullah framed INEC's prior derecognition as fundamentally faulty.
I'm sorry, but I just don't buy that. Let me tell you why.
Go ahead.
Tambol and Abdullah are engaging in textbook rhetorical inflation here.
How so? I mean, the highest court in the land literally ruled in their favor.
Because you have to explain the actual mechanics of what the Supreme Court did. For our listeners, a status quo ante bellum order basically means the court is saying, let's freeze everything and reset the clock to exactly how things were before this legal fight started.
Right, the pause button.
Exactly. The Supreme Court vacated that freeze order. They lifted the pause button, but they did not rule on the actual core dispute, the Nafu-Bala Gombe case, which challenges the fundamental legitimacy of the leadership convention itself.
They just send it back.
They just sent it back to the trial court. The roadblock hasn't been cleared. It's just been moved a few miles down the road.
Wait, let me offer a different analogy because I think moving the roadblock really understates the political impact here.
Okay, let's hear it.
Think of the political landscape as a highly regulated transit system, right? For months, the ADC was this massive bus stuck in the depot because two different factions were fighting over who legally owned the keys.
Sure.
The Supreme Court ruling didn't just clear a roadblock, it officially handed the keys to David Mark and Ralph Arregabelsala, allowing them to turn the engine on and pull out onto the highway. They are driving. They are setting the destination, and that completely changes the flow of all the political traffic around them, regardless of what the trial court might say 2 years from now.
That works if the vehicle is sound, but you are ignoring the fact that the government is actively trying to impound the bus and scrap it for parts.
You mean the constitutional issue?
Yes. We have to talk about Section 225A of the Constitution. This is not just a minor administrative hurdle.
Well, for those who might not follow constitutional electoral law closely, lay out exactly what Section 225A does.
So Section 225A was designed to clear the ballot of briefcase parties.
Briefcase parties?
Yeah, parties that exist only on paper to negotiate endorsements, but don't actually win elections.
The Constitution is incredibly specific. It mandates that to legally exist, a political party must win at least one presidential, governorship, local government chairmanship, or state assembly seat.
Okay.
If you fail to meet those specific performance thresholds, INEC has the constitutional authority to deregister you. They can liquidate the party infrastructure entirely.
Right. So it's essentially corporate dissolution for a political party. Exactly. So while the ADC is throwing a party, because David Mark gets to hold the title of chairman, the Attorney General of the Federation is sitting in the federal high court arguing that the ADC did not meet these constitutional thresholds.
Which is a serious threat.
It's existential. If the AGF successfully argues it does not matter who is holding the keys to the bus, because the bus legally ceases to exist. How can you call that solid ground?
That's an interesting point, though. I would frame it differently. I look at causality here.
What do you mean?
Well, why is the Attorney General of the Federation, the chief law officer of the ruling government, suddenly deploying his weight in this specific federal high court suit right now?
Because it's his job?
I don't think so. If the ADC were truly a fragile, legally doomed briefcase entity, the ruling apparatus wouldn't need to mobilize the AGF to forcefully dismantle it via Section 225A before the 2027 preparations even begin.
Oh, so you think it's a targeted assassination rather than just routine administrative cleanup?
Absolutely. The aggressive push for deregistration is essentially proof of the party's rising political capital. It is a direct reaction to a threat.
I see.
And look at the strategic brilliance of Balaji Abdullah's response. He didn't just play defense. He immediately pivoted from the Supreme Court celebration to aggressively demanding the resignation of INEC Chairman Jalish Amapidin.
Which was quite bold.
By doing that, he is controlling the narrative. He's putting the Electoral Commission entirely on the defensive, framing any future legal attacks, like the Section 225A suit, as partisan interference rather than legitimate constitutional enforcement.
Controlling the narrative only works until a judge bangs a gavel, though.
True, but public perception matters in politics.
It does. But you can spin the AGF's involvement as proof of your political relevance to your base all you want. If the federal high court rules against you, your relevance is legally zero.
Right.
The risk here is that the ADC leadership is communicating a false sense of finality. When you tell your grassroots organizers that the Supreme Court has completely vindicated you, and then say 3 months later your party is formally deregistered,
The backlash.
the psychological whiplash will devastate your base. They are writing checks that their legal reality simply cannot cash.
So, if you are an engaged listener right now and you're thinking, well, if the ADC's legal foundation is genuinely that precarious, why would anyone take them seriously?
Right. It's a valid question.
That brings us perfectly to the second development. If your institutional foundation is under severe legal threat, you cannot rely purely on party infrastructure to win over the electorate. You need a human shield.
Ah, okay.
You need a figure whose personal legitimacy and historical weight are so massive that they eclipse the procedural court battles, which explains the sudden, very discreet pivot to Good Luck Jonathan.
A human shield is an apt way to describe it, though a highly risky one.
Let's look at the strategic logic here. As a South-South politician, Jonathan flawlessly fulfills the strategic necessity for a Southern candidate to complete an 8-year term before power can legitimately return to the North.
Geography is certainly on his side.
But beyond geography, look at his post-presidential profile. He has spent years mediating for ECOWAS. He sits completely above the daily political fray.
Mostly, yeah.
And he is free from the prolonged hyper-partisan failures and the deep-seated electoral exhaustion that critics attach to a serial aspirant like, say, Atiku Abubakar.
That's a compelling argument. But have you considered the sheer weight of the historical baggage he actually brings with him?
Baggage is relative in politics.
Sure, but we tend to view former presidents through a lens of nostalgia. Campaigns, however, are fought on cold, hard records. We are talking about an administration from 2010 to 2015 that ended in a historic electoral defeat for very specific, tangible reasons.
You're referring to the security and economic critiques.
I'm referring to the realities of his tenure. You cannot simply erase the heavily criticized delayed response to the Chibok girls' abduction in April 2014.
Well, no one is erasing
You
it.
cannot ignore the severe deterioration of the security architecture in the Northeast during his watch, or the macroeconomic struggles that defined his final years in office.
But the context...
When you bring Jonathan into the 2027 race, you aren't just bringing in a recognizable name. You are handing the ruling party a pre-written, meticulously documented opposition research folder that has already been successfully tested and proven to work on the Nigerian electorate.
Right. You're asking voters to look backward and defend the past, instead of offering a fresh vision for the future.
I see why you think that, but let me give you a different perspective on how the Nigerian electorate processes history and time. Context really changes the weight of political memory.
Okay, let's hear it.
Yes, those administrative weaknesses existed, and they were the focal point of the 2015 campaign. But what is the defining image of Good Luck Jonathan today? What is the one thing every citizen across party lines remembers about him?
The phone call.
Exactly. His 2015 concession call to Muhammadu Buhari, that was the first peaceful transfer of power from an incumbent to an opposition candidate in Nigerian democratic history.
It was a huge moment, I'll admit.
And in a contemporary political climate that feels increasingly fractured, cynical, and structurally unstable, that single act of democratic statesmanship has appreciated exponentially in value.
You think it outweighs his entire record?
I think it overrides the administrative critiques because it speaks directly to character, stability, and institutional respect. For a coalition desperate for a historically significant statesman to legitimize their movement, that 2015 legacy is the ultimate political shield.
Well, I agree that the concession call is a powerful piece of political mythology.
It's more than mythology.
But a political shield doesn't govern, and a myth certainly doesn't secure a highly contested party nomination without a brutal fight. Which brings us to the most volatile mechanism of this entire strategy, the internal coalition calculus.
The primary field.
Let's look at the sheer mathematical impossibility of the current aspirant field within the ADC.
It is a crowded field, no doubt.
Crowded is an understatement. You already have Atiku Abubakar, Peter Obi, Rabiu Kwankwaso, Rotimi Amachi, and Mohammed Hayatuddin.
Heavyweights.
Right. These are not minor regional players trying to raise their profile for a cabinet appointment. These are men with massive political machines, deeply entrenched ambitions, and billions of naira invested in local delegate networks.
True.
The ADC is supposed to be managing this tension through a delicate collegiate system.
Let's define that mechanism for a moment, just to be clear. A collegiate system process isn't a straightforward winner-take-all open primary, right?
Correct. It is essentially a consensus-building mechanism where party elders and regional power brokers attempt to hash out an agreement behind closed doors before subjecting the candidates to a potentially destructive open vote.
Exactly. Now explain to me how introducing a former president into that incredibly delicate ecosystem does anything other than detonate the entire structure.
Well, I'll explain exactly how it works. I'm not convinced by that line of reasoning because you are assuming Jonathan enters the primary as just another combatant in the arena, competing for the same delegates.
How else does he enter?
Doesn't the introduction of a former president actually serve as the perfect institutional bypass?
An institutional bypass? How so? Think about the mechanics of a primary involving Atiku, Obi, Kwankwaso, and Amahi. It would be a total bloodbath.
Oh, absolutely.
They would spend astronomical amounts of money, weaponize their regional bases against one another, and destroy each other's reputations before the general election even begins. The winner would inherit a deeply fractured party.
That is the risk, yes.
But Jonathan operates on an entirely different frequency. He provides a universally recognizable, historically elevated figure around whom all these other aspirants can gracefully coalesce without losing face.
Gracefully coalesce?
Yes! It is much easier for a Kwankwaso or an Obi to stand at a podium and say, "I am stepping aside for the former president in the interest of national unity," than it is for them to step aside for a direct peer.
Gracefully coalesce in Nigerian electoral politics. I think you are applying a level of academic idealism to a highly ruthless transactional environment.
You really don't think they would accept a consensus arrangement if the figure is large enough?
Let's use an analogy to explain the mechanics of what you're actually asking these men to do. Bringing Jonathan into this primary isn't an institutional bypass. It's a hostile takeover.
A hostile takeover?
It is exactly like asking 5 startup founders who have been grinding for years, spending their own capital, building local infrastructure, and courting investors to suddenly hand 51% of their equity over to a retired CEO just because he has widespread name recognition.
But
you are alienating the very billionaires and grassroots organizers funding your party.
But if the retired CEO is the only one who can actually take the company public and secure the win, the founders will compromise.
Look at the historical precedent. We have seen this exact play before.
You mean 2021?
Yes. In 2021, a faction within the ruling APC approached Jonathan with a very similar proposition: be our stabilizing consensus candidate. He publicly acknowledged receiving a party card in Bayelsa, but he ultimately declined to run.
That was a different context, though.
Why did he decline? Because the mechanics of actually securing the ticket without tearing the party apart were too messy.
Right, but
The fact that the unnamed ADC chieftain admitted to legit.ng that the party hasn't even decided if Jonathan would get an automatic ticket and that these current talks are quote-unquote discreet suggests that same massive hesitation is still there.
So you view the Jonathan talks as a sign of weakness, not a masterstroke.
Absolutely. If Jonathan enters without an automatic ticket, Atiku will argue he has a stronger, more recent electoral mandate.
That's true. He would.
Obi Space, which is built on anti-establishment sentiment, will reject what they see as a literal return to the old guard. Kwankwaso will demand regional concessions, the parties simply cannot guarantee.
It would be complicated.
Instead of a unifying figure, Jonathan becomes a lightning rod. The very act of courting a former president proves the ADC lacks confidence in its existing field of heavyweights. It's a symptom of structural panic.
I disagree. It is strategic audacity.
Audacity?
Yes. To effectively challenge an incumbent government in Nigeria, you need to consolidate absolutely every ounce of political capital available.
Even if it risks breaking the party?
Yes, managing those egos through a collegiate system is a monumental task. But look at the dual approach the ADC is taking. By aggressively fighting for their legal legitimacy, evidenced by the Supreme Court vacating that paralyzing order, and simultaneously expanding their political footprint by courting a figure like Goodluck Jonathan, they are building the only kind of platform capable of surviving 2027.
That's a very optimistic view.
They are forcing the ruling party, INAC, and the AGF to react to them. They are dictating the pace of the political game.
Dictating the pace, perhaps, but running toward a cliff.
A cliff?
If we summarize the reality of their position, the ADC is building a very impressive, highly publicized house, but they are building it on an active fault line.
The legal cases.
You have the Attorney General actively pushing Section 225A deregistration. You have the substantive leadership case initiated by Nafiu Bala Gombe still looming over them at the federal high court.
Which they are fighting.
And into this incredibly fragile legal container, they're attempting to pour a highly combustible mix of massive political egos and the deeply polarizing legacy of a former president.
Right.
The addition of Goodluck Jonathan might not be the capstone that finishes the building. It could very well be the final unsustainable weight that collapses the entire structure.
Yet despite those undeniable legal vulnerabilities and the guaranteed internal friction over the ticket, we have to acknowledge one fundamental truth about April 30, 2026.
Which is?
The ADC's aggressive maneuvering has worked on the most vital front in politics. They have successfully made themselves the absolute center of political gravity right now.
Well, they definitely have our attention.
Every single calculation for 2027, from the ruling party in Abuja to the regional power brokers across the country, now has to account for what the David Mark and Ralph Argbasola leadership is doing, and whether a former president might be carrying their flag.
I will concede that they have captured the spotlight entirely. No political strategist in the country can afford to ignore the ADC at this exact moment.
Exactly.
But as we know all too well in politics, capturing the spotlight and actually surviving the legal and internal scrutiny are two entirely different disciplines.
Absolutely. And that perfectly highlights the incredible value of looking past the celebratory press releases and the surface-level political signals to truly understand the structural realities operating underneath.
There's definitely a lot under the surface here.
There is clearly much more to explore here, specifically regarding the exact legal mechanics of the AGF's deregistration suit and how this volatile collegiate system process will actually unfold when those massive egos are finally forced into a room together.
It'll be fascinating to watch.
It will be. We leave it to you, our listeners, to draw your own conclusions about what happens next. But remember our opening paradox. The next time you see a grand political celebration unfolding on the main stage, ask yourself, what paperwork is being filed in the shadows?
A question we should all be asking.
Thank you for joining us.